Everyone, I'm Grace Lee. I'm the Pro Bono Director at the ACLU of Southern California, and I get the pleasure of supporting some of our intern programming and our Brown Bag series. Um, Before I introduce Hiroshi, I'm just going to do a couple of housekeeping updates. We have some written materials that will be provided to all the participants of today's session. Those will be emailed out afterwards. We will be providing 1.5 MCLE credits to California attorneys. Later in the session, in the chat, I'll drop a link for folks to register for that MCLE credit, and then I will email out MCLE certificates probably in a few weeks after that registration has gone through. A recording of this session will be provided on the Center of Immigration Law and Policy's YouTube channel, and so that link will also be sent out to registrants or to participants today. And we are recording this session, although for privacy purposes, I'll just let you know that no one's attendance or Q&A will be reflected in that recording. Please, throughout the session, utilize the Q&A function if you have questions for Professor Motomura. But I'm happy to introduce Professor Motomura, or Hiroshi, as we like to call him. Professor Motomura is the Susan Westerberg Prager Distinguished Professor of Law at UCLA School of Law, also the faculty co-director for the Miñana Center for Immigration Law and Policy at UCLA, the author of numerous books and case books, winner of many distinguished teaching awards at UCLA, my law professor from UCLA years ago, a great friend to the ACLU. He's done this session so many times, has trained and inspired many, many summer interns, law clerks, and future attorneys. So I'm going to pass it off to Hiroshi. You're in great hands, and we're so grateful for his time with us. Thank you, Hiroshi.
Thank you. And Grace, you can hear me okay, right? Okay, that's good. Okay. Thanks for being here. Really appreciate it. And just a couple of preliminary things. I mean, thanks for all of your work in general, but also especially this summer. Really appreciate you taking time, and especially uh, if I know this conflicts with the opening of the World Cup, so I really appreciate this. But I think there are a few more games coming up in the next few weeks, so you're not totally missing out. Um, so this is a 90-minute distillation of my 52-hour course in immigration law. So how do you get from 52 hours to 90 minutes? Well, one thing that helps is I'm not going to ask you any annoying questions. I'm just going to tell it like what I think it is. So my goal, like the flyer said, is not to cover details. It's instead to make you feel like nothing feels completely unfamiliar. Everything seems within your general grasp. So it may be that I seem to go very quickly, but the recording is there, and the slides will be available. So, and this is really just a sense of how things are going in general, and then you fill in some of the details. My focus is going to be on the law. And I say that especially this year where sometimes the law doesn't seem to matter. But I do think it's important to really start with this. And so I want to focus on the things that actually are hard to pick up on your own. A lot of you are more familiar with the policy than with the law. And so I want to kind of evenly do both those things. But the other thing I want to say before I start, I want to acknowledge that immigration law, it's very technical, but it's also very human. And so my focus on the laws and the statute is not intended to take away from that. You know, I'm from an immigrant family myself. I've been through a lot of the things that we're going to be talking about today. And so I do this kind of knowing that a lot of this times the law isn't necessarily what really happens, but I think it's still important to know it. So I'm going to go through this. So I hope your seatbelts are fastened, and I'll try not to talk too fast. But I also want to invite people to put questions in the Q&A because that way I can see what's going on. I'll do my best to monitor them, and I'll interrupt myself with answers to your questions. Yeah, and I'm not sure I'm going to get to all the questions, but I want you to just throw in anything in the Q&A. I'll see that as we go. Okay, so here we go. Um, yeah, here we go. Like I can't get this started. Um, okay, just a quick overview. Why does it say argument and prediction? This is an overview of all the topics because, I think we only learn two things in law school. One is how to argue, and the other is how to predict. That's really what it comes down to. And I'm going to focus today on the argument. In other words, argument is what you say to a court, to an adjudicator, um, and what the law is. The prediction is often politics. It's often practical outcomes. It's often the money that clients have. I want to acknowledge that the prediction can be what's important, but I think it's really important to start with the argument because it's only by knowing both of these things that you can really help people. So the topics here, I want to talk about citizenship. I want to talk about admission categories and admissibility, the procedures for admission removal, deportability, something about the federal executive branch and federal courts, state and local governments, and some sources to look into because a lot of this is what I hope to convey actually today is not the actual details, but really how to look up everything. Okay. Um, so, citizenship by birth. Well, this has been under attack lately. The executive order from the White House is trying to redefine citizenship based on the 14th Amendment. But the main thing I want to say is that citizens of the United States, there's a couple of ways to become a citizen. So when we talk about citizenship, one of the ways that it applies to a lot of people, but of course not all people, is birth on U.S. soil. The executive order tries to rework that and really restrict it to say that you must have one parent who is either a permanent resident or a citizen, and so this would exclude children of the undocumented and children of people who are here as temporary workers or as students, and so it has a huge potential impact. We could talk for a whole 90 minutes about this one case, Trump versus Barber. I'm going to resist that temptation because the whole point here really is to give you a sense that some people are citizens, and some people I've run across people who don't realize they're citizens, so that's something always to check. You can also be a citizen based on a statute. For example, birth outside the U.S. to one or two U.S. citizen parents. And that really depends on the ties of those U.S. citizen parents to the United States. And I was born outside the United States. My father was a U.S. citizen, but he had not lived in the United States. He didn't have enough ties to the United States, so he could not give me citizenship, which is why I ended up stateless, which is a whole different story. But I could tell you at some other time. But there's other ways to become a citizen is naturalization. And you can naturalize. These are basic requirements here that I've listed. Years as a permanent resident, physical presence, American history and politics, English language ability, this sort of a test of attachment to U.S. constitutional principle, whatever that might mean, and good moral character, which has historically been meant criminal convictions. So I have concerns the administration is trying to read it more broadly than that. And I don't want to downplay the fact that there's a substantial fee. You can also be naturalized if your parent naturalizes. You can come in on your parent's petition. And there's also circumstances where kids are brought to the United States. Often this is a question of adoption, and it's an automatic naturalization. It's not birthright citizenship technically, because it's not from the moment you're born, but it can be from the moment that you're brought to this country. And this affects a lot of children who are adoptees. Um, and how can you lose citizenship? You could be denaturalized. One of the things going on the Trump administration is trying to do is to go in and reopen cases and take citizenship away, which has a lot of concerns at various levels, including going after people who actually maybe it's very difficult to defend themselves because a lot of information isn't there. Um, this, by the way, is something, a theme I think is worth recognizing. A lot of the law, one of the reasons the law doesn't matter as much as it should is I think in many cases the administration is ignoring it, but also I think there's often a message being sent by the positions taken by the administration. Denaturalization is one. Another is, frankly, people are afraid to naturalize now because they don't want to deal with the federal government. I don't blame them. Whether that's the right course of action depends on the circumstances, but that's denaturalization. Expatriation is a term that you often hear that it's not like it's not undoing the naturalization. It's taking citizenship away. It could apply to someone who's naturalized or it could apply to birthright citizenship. And the Supreme Court said you can only give up your citizenship if you intend to do so. There's a lot of case law on this. Um, and then the United States recognizes dual nationality. Many other countries don't. It takes the law of two countries to really perfect dual nationality. Some countries, if you naturalize in the United States, you give up that old citizenship. Some countries allow you to retain it. A lot of different things there. So to show you how quickly I'm moving here, I just covered a whole week of the class. Um, this is a bit like I don't know if some of you saw this is very old, but it's Saturday Night Live routine. Um, Father Guido Sarducci's 5 Minute University, and it's like everything in 4 years they compress into 5 minutes on the theory that everything you remember from college after a few years after the fact can be compressed into 5 minutes. I hope that people come out of my immigration class remembering more than 90 minutes, but I do want to it's just an example of people going pretty quickly. So let's just take this real scenario, and this you can imagine someone coming to your office and saying, in this, this is a direct services situation. Charles has been a permanent resident of the United States since 2017. Permanent resident is someone who's allowed to stay in the country indefinitely, lawful permanent resident, sometimes called the green card holder. And they can stay in the status indefinitely, but there are certain things that only citizens can do and not permanent residents. And people who are permanent residents can be deported. We'll talk about deportation later, but that's one of it's often said that voting is a big difference between citizens and non-citizens. Also, the security of your residence is a big difference. Last month in Nairobi, he married Doris, a citizen of Kenya who has a 6-year-old child by previous marriage, which was terminated by a valid divorce. Doris wants to come to the United States with a child as soon as possible. So I'm just going to go through this pretty quickly. If it were actually my class, and some of you may take my class in the fall or have taken it in the past, and at this point I would say, well, what do you think? What should we do? Here are a couple options here, and I'm using this kind of to illustrate what you do. Um, there are categories that you can file in, and there's a category for the spouse and child of a permanent resident. So that's Doris and the child. So that fits into category. We'll get into the details of this in a minute, but it's a family. It's called the 2A preference, the second preference, category A. And there's a couple ways to think about the child. The child can come in with Doris. It might also be the child qualifies as Charles's child, as a stepchild. That's also a matter of definition, but there's a statute that defines sometimes can define a stepchild as a child. So the point I'm trying to make here really is that one of the things you have to figure out is how Doris and the child fit into the system. And we'll talk more about details of the system, but I just want to set that kind of a stage. Another option here is that Charles could become a citizen, naturalized, and then file a more favorable petition called immediate relatives, because from photographic memory of the previous slide that you can become a permanent resident if you've been here for 5 years and you meet those other requirements. So one of the things you might want to talk to Charles about is, do you want to become a citizen? That might expedite the process. It might slow it down too, depending on what it involves to become a citizen. But Charles might also say, I don't want to become a U.S. citizen because it'll cause me to give up or lose some rights in my home country, including inheritance rights or whatever it may be. So that's just to kind of set the stage. You don't have to choose right away. It could be that you could file the petition as a permanent resident, and then if you naturalize, it would convert to a different category. And there's certain reasons why you want to be in some categories or other categories, and we'll talk about them more in a minute. But I just want to give you a concrete feel for, and I don't know if this gives you sweaty palms or not, but imagine Charles calls you up. Imagine Doris calls you up. What do you say? Well, I mean, this will help you kind of think it through, and I hope in the next few slides gives you a better sense of this. Okay, so this is now to elaborate on the scenario. Immigrants, the word immigrant is a technical term. It's also obviously a normal English word, but it's in the statute, an immigrant is someone who is a permanent resident, someone who's a green card holder. And for the color of certainly the original color of the card. And so there are a couple ways, there are different ways, there's more than a couple, there's several ways to become a permanent resident. One is based on family. So how do you get to be a permanent resident based on family? Well, one is you could become an immediate relative, right? So recall that for Charles, it could be that if he's a citizen, then it turns out that Doris and the child might be a spouse and child of a U.S. citizen. There's no cap on how many people are admitted, and that's a big advantage. And it could also be the parent of a citizen. It could be Charles could, if he becomes a citizen, he could also petition for a parent. But that requires Charles to be 21 years of age. And so, it's not like someone's born and can immediately petition for their parent. They have to wait till the 21st birthday. It takes 21 years for someone born in the United States to petition for their parents. But there's also it's called preferences, but actually they're less it's less preferred in practice than immediate relatives. Preferences are categories with annual caps. And there's also other constraints. I'll talk about inadmissibility in more detail later, but the idea is that it often is the case that family-based immigrants have trouble meeting the financial support requirements. It's called avoiding public charge inadmissibility because if you are likely to become a public charge, you are not, then that would make you ineligible even though you fit in the category. So, basic idea here is that Charles has to think about, I married someone, what category they fit into. It might be one of the preferences if I'm not a citizen. But if I am a citizen, I'm talking about immediate relatives, and that may be an advantage of not having an annual cap. I've also got to worry about financial support. That's really what the point of this slide is. Um, okay. Now we're several weeks into the class, actually. Um, here's a little bit more about family preferences. This is what they are. So you can see that Doris and the child um, would 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 fit in as long as Charles is the permanent resident. They would be in the family 2A category. It's 88,000 a year, and you can see that there's a category. The most distant relationship is brothers and sisters of citizens who are over 21. So okay. Now these are numerical limits by country. I'm sorry, by year, and of course that leads to backlogs, which we'll talk about in a minute. Um, so in any category, if someone who is coming into if you fit in the category, like Doris fits into the spouse of a citizen. I'm sorry, Doris fits in this spouse of a permanent resident right now. It's because Charles is a permanent resident. Um, the the child can come in, with Doris. The child again might also be coming in on their own if Charles becomes a citizen. But as it currently stands, um, well, actually, no, let me take that sentence back. Even now, the spouse would come in under the category, and then they could bring in other people. So, in other words, or giving a more straightforward example, jumping ahead a little bit, if someone comes to work in this country, they can bring their spouse and child with them. That's really um, the main thing. And so you have coattails, basically. Now, this is a quirky thing, but it's something that often comes up. If you're an immediate relative, you do not have coattails. You only can bring in people on your coattails if you are in a preference category. Let me give you an example of this because it's kind of hard to explain in the abstract. You're a citizen. You're 21 years old. You can petition for your parent. Okay, we know that from a couple slides ago. So it turns out that your parent cannot bring in their. Let's say that your parent has divorced your biological parent or your prior parent, has married someone else. You can petition for your parent, but your petition cannot bring his or her new spouse with them. And the reason is that immediate relatives cannot use this provision. If that I just went by that too quickly, don't worry about it. You can kind of store that in the look up later category. But anyway, the main point is that people can come in with the what's so-called principal immigrant. There's also something that's really important, which is there's a limit on the number of people who can come in on the family and employment preferences combined per country to about 25,000 a year. And this means that you have to wait longer in these categories to come to this country if you're from certain countries. Right now, it's China, India, Philippines, and Mexico. And so they're longer waits. And we'll talk more about how long the waits are in a minute. Um, There also, in this administration and in the first Trump administration, there have been extraordinary bans that target people from countries that the administration basically doesn't want, people to come from those countries. And so there's, I think it's fair to call it a Muslim ban in 2017, and now there are bans on other targeted countries in terms of actually keeping people out or pausing processing and things like that. So these are all things that come in to modify what you might think of in terms of the basic categories. Um, let's see. I have a question here in the chat, which is, is it a catch-22 sort of a situation to avoid the public charge of admissibility for an undocumented person who has assets in the United States? Um, Not a public charge, but um, okay. One thing to understand, which is, a lot of the stuff gets really technical, but the public, I'm not sure there's a complete answer to the question, but it's a prompt for me to explain this a little bit more. The public charge rule basically requires support, um, and doesn't look at in the main, it does not look at the assets or the income of of the person who's immigrating, whether that person is undocumented or not. Um, it really just looks at the resources of the person who's essentially sponsoring the individual. And so there are situations where the person who's going to get the green card has substantial earning potential and even substantial assets, but those are not counted. What counts is the people sponsoring, and a lot more to be said about the sponsorship requirements, but I'm not sure it's a catch-22 situation as much as it's actually quite burdensome, and it also can make it hard for people to qualify or even to apply. One of the things that the Trump administration has been trying to do consistently is to make it harder and harder for people to come in without substantial assets. And we'll talk more about that later, but I think that's a lot of what's going on. I apologize if I didn't fully answer the question. If I didn't, please, focus me on the aspects that I didn't get to. So how long do you have to wait? Doris says, or Charles says, how long do I have to wait? I kind of feel for the categories I'm in, but I'm not sure, like, how long do I have to wait? So this is something called the Visa Bulletin. It's on the State Department website. It's issued once a month. So what does this mean? It means, let's just take a look at, you know, Doris is going to be in family 2A. That means she's the spouse of a permanent resident, right? And we know that if Charles naturalizes, you don't have to worry about this chart because if Charles naturalizes, then Doris becomes an immediate relative. But if Charles does not naturalize, Charles is still a lawful permanent resident, and Doris is in the family 2A category, the 2A preference, a lot of people would say. What does this mean? It means that um, you get a date assigned to you called a priority date when you file your first paper as part of the process. So this would be a petition by Charles for Doris and the child, I guess. And Your priority date basically marks your place in line, and you have to have a priority date in Doris's case, in the child's case, before January 1st of 2025. This is the visa bulletin for June of 2026. So you had to get into line basically 18 months ago to get to the front of the line now. This assumes a couple things. A couple things to add to this. One is I'm assuming that Doris is born in Kenya because it depends on where you were born, not what country you're a citizen of. So you got to make sure you put Doris in the correct column. All chargeability areas except those listed. This shows you that if you are from Mexico, for example, and you marry a permanent resident, you got to wait longer. You've been waiting a year longer to get to the front of the line now. And this is a function of the fact that preference category immigrants from Mexico are limited to a maximum of 25,000 a year. And so that kicks in and says, well, if you're going to be the person that goes over that limit, you got to wait, even if other people got into line after you. I should also mention that you cannot look at this and automatically say to a client, we're going to wait 18 months. All you really know is that if you are at the front of the line now, you've been waiting for 18 months. So it's like going to a restaurant. You go to a restaurant and say, how long will I have to wait for a table? The host says to you, well, we're seating people now who've been waiting for 18 minutes. That doesn't tell you when you're going to have to wait till. That it could easily be the case that you have to wait longer or shorter, depending on how many people get into line and show up at the restaurant after you. Um, so, okay. How else can you get in? Well, there are also job categories that allow you to. Um, there's also job categories to the there are also job categories, and these are five preferences, so-called preferences. But in plain English, they'd be uh, categories. They should be called categories, not preferences. I mean, that's just more plain English. But there's different categories here, and notice that it's there's a separate number of people who are so-called extraordinary ability that's limited to 40,000. Then those get used up, and then there are people with advanced degrees. There's another 40,000. Um, they may need something called labor certification, which is proof that you're not taking a job away from a U.S. worker. There are people with college degrees, plus a few other workers without college degrees, another 40,000. But only 50,000 are for so-called unskilled workers, many of whom are actually highly skilled, but they don't have college degrees. They need a labor certification. Um, and there's so-called special immigrants that include something you may be familiar with, which is special immigrant juvenile status. The point really, and then they're investors. One key point here, two key points. One is that many of these people who like the 40,000 in second preference category, they're not just the people with advanced degrees. They are people who are the spouses and children of people with advanced degrees, and that's the result of that's the result of the law that says that people in the preference categories can bring people with them. And that's the other big point I want to make is there's a huge mismatch between the demand for workers in this country, both by workers and by employers and by community members. There's a big mismatch or it's out of sync with the lawful pathways to come. I mean, it's so hard to come to this country. Um, if you have a job waiting for you and you have skills, or even if you don't have skills, even if you're just willing to work, it's so hard to come lawfully. There's no line to stand in anymore. And that's the genesis of a lot of, debates politically, because these are very small numbers, given the size of the economy. Got a couple questions here. Can someone with later priority date receive relief first? I'll get to that later because there are certain ways you can get relief even while you're waiting. There are certain ways you might be able to either regularize your status or be in a position where you have legal protection while you wait. We'll talk about that. How's it determined which countries have caps? Congress put that in the statute. Congress put it in the statute, and that ended up there's a formula that used to be 20,000 a year. Now it's 25, it's 25,000, about 400 a year. Um, okay. And then there's another question. The combined income of spouses, does it count for public charge? Um, yeah, I'm not sure I totally understand the question, but let me just sort of state how it works is again, the sponsor has to have enough income to support the person being sponsored. The law generally um, ignores the assets and the income of the person who's coming to the country. Now, there's exceptions to this. It depends it's one of the things I learned in law school is qualify virtually everything, and this is a good example. But this is one of the reasons why the laws are actually quite draconian. You don't really get credit for the income that the immigrant might earn. Okay. Again, if I didn't answer that, please re-ask it in the Q&A. Okay. So here's the visa bulletin for employment preferences. The reason I put employment in quotes is because it includes investors, for example. But this shows you a few things. One is that if you're from Kenya and you have, say, a master's degree, and you can show you're not taking a job away from the U.S. worker, in some cases, that requirement is not imposed, but you're in a situation where you in that the C means it's current. It means that there's no waiting list. There's definitely processing time, but in theory, you're at the front of the line. Compare that to if you have the same credentials. Let's say you have a master's degree and you're born in China. The people getting those now are people who got into line almost 5 years ago. India, you have a master's degree. They're processing people now who got into line in 2013. So you can see the effect of the per country limits imposed by Congress. And I'm not going to get into what the specific categories are right now, but the fifth one is just to mention is for investors. And so if you're an investor, which can cost quite a bit of money, I mean, kind of in the $1 million type range. I mean, there's different programs and different amounts for different kinds of investments, but and different rules for investments. But there are a lot of people born in China who have the money to become an investor, but they're waiting. They're getting the front of the line if they got here 10 years ago. That's what the September, 2016 means. Um, okay. There's diversity immigrants, so-called diversity immigrants. That's just the name that's often used. It has an interesting history because it was originally enacted to provide extra immigrants for people from Ireland to offset the reduction in European immigration as a result of some changes the Congress made in 1965. It turns out the diversity immigrants um, it's basically it's a lottery, 50,000 a year, but not for countries with high admission countries. In practice, this has really become an important avenue for migrants from around the world, very prominently from Africa. Many African immigrant communities have been significantly positively impacted by the diversity lottery. I don't know if you want, it depends on how cynical you want to be, but I mean the DHS paused diversity processing for so-called security reasons. And one of the patterns we're seeing in this administration is really targeting countries with either majority Muslim countries and/or countries in Asia and in Africa. Maybe consistent with the president saying, or asking, why don't we have more people from Norway? So anyway, that's the law on diversity. There's all kinds. Obviously, I'm going fairly quickly through this, but this is give you, if people uh, ask you about that, that's what that's about. Let me just make sure I didn't skip anything. Okay. Um, Humanitarian protection is another big piece of stuff. There are several ways to get humanitarian protection in this country. One is there's something called the Overseas Refugee Program. There's an annual ceiling. These are people selected from around the world, often through a combination of sort of foreign policy and political entanglements and perceptions of need. It was ranging from 50,000 to 120,000 until Trump came in the first administration and reduced it to 15,000. Um, and then Joe Biden came in and increased it to 125, but the practical numbers let in were limited because the first Trump administration hollowed out the bureaucracy. And so a lot of times what really is going on here is a lack of capacity to give people the things that they should have right to under the statute or under the Constitution. Now, the only refugees that the Trump administration has been letting in are white Afrikaners. So that's something. Um, okay. Um, Now, another thing that's going on here is asylees at the border or inside the United States. So overseas refugees are let in from outside the country. I mean, overseas is kind of a misnomer. They don't have to be overseas. They just have to be outside the United States. You can get asylum but only coming to the country at the border or inside the United States. You could come. A lot of people come to the border and say, "I want asylum." A lot of people are in the United States and ask for asylum. Um, this has been, the Trump administration has been on something of a crusade to make it hard to apply for asylum. It invoked Title 42 to end, to basically close the border during the pandemic. But more recently, it is in various ways closed the border to asylum applicants. And this one aspect of this was argued in the Supreme Court at the end of, I guess, at the end of March in a case called Al Otro Lado, which is a case that is really about, whether you what happens at the border. Does everyone have a right to apply for the border, and do you have to cross the border, or can you be stopped outside the border? One of the things we've been doing at our Miñana Center for Immigration Law Policy is that my a friend and co-director Ahilan Arulanantham argued on behalf of TPS recipients in the Supreme Court just a few weeks ago. Temporary protected status is a way to protect people, not giving them refugee admissions, not giving them asylum, but really is a temporary status, as the name implies. But it can be renewed, and in some cases, it's been renewed for many years. The Trump administration has been trying to end this. Um, okay. Um, Parole is another way of humanitarian protection, and that is temporary entry to the United States without formal admission. You're allowed to come to the country, often for a period kind of like the TPS period of a few years. It can be renewed, it can be not renewed. One of the things the administration has been trying to do is to view it's trying to cut off asylum and then say anything other than asylum. Basically, it's cut off asylum and refugees. It says an exception for white South Africans. It then says that we've had these processes of temporary protected status and parole, which is numerically super significant, but it's viewing them as somehow illegitimate and trying to get rid of them. I should give you a historical note, which is that temporary protected status and parole have a long history. Temporary protected status has statutory roots in 1990, but has administrative precursors before that. And then parole has been around since the Hungarian uprising in 1956. It's been used for Cubans, Nicaraguans, Ukrainians, Afghans, and other situations. And so this is what's going on here. But if people talk about parole, people talk about TPS, this is what they're talking about. Victims and survivors of crimes and trafficking, that's also a form of humanitarian protection, I think. Different ways you can define humanitarian protection, but these are people who are victims and survivors of trafficking or of crimes in general. Um, and Now, all these the refugees and asylees, they automatically get permanent residence status after a year. But these other statuses, temporary protected status, parole, U visas, T visas, there are various degrees of pathways to green card and pathways to citizenship. Many people with temporary protected status and parole, for example, do get regular green cards and citizenship eventually, but often it's because they've made a life in the United States and they have a job or they're married to a U.S. citizen or something like that, and not because there's an automatic conversion of TPS, because there's not. Um, okay. I know I have a question here about just going back a bit about the immigrant being employed. And I'm not sure I can totally absorb this right now because it's kind of a long um, question. Goodness. Yeah, I'm gonna let me go back to this because I'm having a hard time following this while it's hard to read and talk at the same time. And I could just pause, but I'm just afraid that I'm going to run out of time. So I'll come back to this if I can. Um, Okay, there's another question, which is in the Charles example, right? Trying to sponsor and petition for a spouse outside the United States. How does the example change if the spouse is inside the United States, if at all? Um, this goes to something I'll get to later, so I'll flag this and then get to it. But basically, you can get a green card from inside the United States, or you can get it from outside the United States. Outside the United States, it's called consular processing. Inside the United States, it's called adjustment of status. We'll talk about what you can access, how you can access both of those, but that's a big difference. It can have all kinds of practical differences and legal differences, which I'll get to. So it could really matter. Um, okay. Um, but you can also come to the United States as a non-immigrant. There are some obvious examples here that I've listed: tourists and business visitors, students, temporary workers, treaty-based visas. Some treaties with the United States government provide, for example, someone from Japan has a treaty that allows certain people to come temporarily but indefinitely renewable if they are investors or involved in international trade. One of the things you may have seen is that the Trump administration has imposed a $100,000 fee for new H-1B workers. That's a type of temporary worker. That was struck down by a district court in Massachusetts last week. We'll have to see what happens with that. The theory of the striking down was it's a tax that the president doesn't have the power to impose. I'm just sprinkling in the policy here and litigation, not because it's a complete coverage of those aspects, but to show you that a lot of the stuff is deeply contested, and a lot of the stuff is stuff that the Trump administration has been targeting, not just in terms of enforcing immigration law against undocumented people, but also making it harder to come to the country legally through traditional channels. Notice that some of these non-immigrant categories are limited in time, um, and and some of them are not. I mean, there's no numerical limit on the number of students. There is a numerical limit on the number of H-1B workers. Um, and some of them may lead in practice, and the law, I think, recognizes this possibility. Some may lead to permanent residence via adjustment of status. Um, and this goes back to the question about, does it make a difference if Charles' spouse is outside the United States or inside the United States? Well, if they're inside the United States, they can use adjustment of status. I got another question that the option to adjust status is going away. I'll talk about that. That's an important, very recent development, and another example of this administration's attitude. Um, but one thing that's really important to recognize is that many permanent residents started as non-immigrants. It's very routine for people who are in a so-called temporary status to become permanent residents. It's also significant that many people who are green card holders at one point in their lives were undocumented. So it's not like people just get into three categories of undocumented, non-immigrant, and immigrant and stay there for the rest of their lives. There's a long history of people who are undocumented getting green cards. There's a long history of non-immigrants getting green cards. Um, okay. Um, so this gets actually to this question of adjustment of status. Admission procedures, it's a two-part thing. You've got to qualify in a category, usually through what's called a petition. Charles petitions for for the spouse and child. If this were an employment case, either the employer petitions for the non-citizen, or in some cases, some job-based categories, the non-citizen could petition for themselves. Again, this is another detail, but you have to qualify in a category. But just because you qualify in a category, you're not home free. You got to do a couple things. One is you must not be inadmissible. In other words, many people who fit in a category are not allowed to come in for various reasons. One of them is lack of financial support, and that we already talked about that. There are others that I'll get to in a minute. Um, there's a couple ways um, you can you can change your status inside the United States. Um, um, and the one way is to adjust status. Um, well, let me start all over with the third main bullet point. You can be admitted in that status. You can go to an embassy or consulate outside the country and get what's called an immigrant visa and come to the border. Then you've the first time your first day in the United States, you'd be a permanent resident. But a lot of people change inside the country, and that's called adjustment of status. So adjustment of status to permanent resident. Now this goes back to a question that someone asked a few minutes ago. Yes, there's a new policy the Trump administration is doing. The history of adjustment of status is that there's case law, administrative agency case law that says that discretion should be exercised in favor of adjustment. The statute makes a discretionary judgment, but administrative case law makes plain that it's only under the worst circumstances. Certainly being in the country without status is not a worse circumstance. So typically, it's been fraud on the U.S. government would be one, but there's also case law that says that fraud on some other government is okay. Um, anyway, the new policy is to really treat adjustment as available only in extraordinary circumstances. Um, this is a major shift that has a lot of different implications. One is that if the people have to leave the country, they're put in this precarious situation. They don't know when they're going to come back. They have fewer avenues to review a decision, get the decision reviewed if they're denied. And it's very disruptive to obviously the lives of the people who are affected, and to their employers or everyone who's associated with them in real life. And so this is yet another way that the administration is not just ramping up enforcement, but is also just making it hard and there's a whole bunch of ways that this happens, but this is one. And so we'll have to see how that gets challenged. The you can also change non-immigrant status. A lot of people change from student to temporary worker. Although again, the cutback on H-1Bs is one of the examples of making it hard, and frankly, is deterring people from coming to this country. Oh. There's also processing backlogs. I don't want to downplay the practical aspect of this because um, the waiting times have gotten longer and longer, which I think is a reflection of the administration's and Congress's unwillingness to recognize immigration as a normal part of American life. And so there's no the backlogs are huge in immigration court and in the petitioning um, process. I have a question. Well, let me get to the question about TPS and inadmissibility in a minute. But um, that's that gets to this slide. Inadmissibility. Um, By the way, we're already like if you started my class in on October, I'm sorry, if you started in August, we'd already be in October. Um, so each of these slides, in my actual class, we spend a few days on. Um, and but as I said, I ask a lot of annoying questions, and I'm not doing that today, I hope. Um, Inadmissibility, well, just because you qualify doesn't mean you can get in because there are examples of inadmissibility grounds. One of them I covered is public charge. You can also be inadmissible because you were in the country without lawful presence. If you have prior unlawful presence, that might be a ground for not giving you a green card. This gets very convoluted, which I'll get to in more detail later because there are times when that applies, there are times it doesn't apply. Criminal convictions can be a source of inadmissibility. There are also some general grounds for national security, which is, frankly, very vaguely defined, and can definitely run into um, some issues with regard to free speech. Um, just because you have an inadmissibility, you can still get a waiver. Most of these grounds have waivers. Um, Most of these grounds have waivers, for example, for prior unlawful presence for some crimes. The question in the Q&A is, if someone holds TPS, what has that related to inadmissibility? Well, I mean, TPS has its own eligibility rules, and so you can think of them as, I suppose, as inadmissibility rules just for TPS. But let's say a TPS holder marries a U.S. citizen and wants to get a green card, then they'd have to comply with the admissibility rules, with the inadmissibility rules that apply for to getting a green card, whether through adjustment of status or consular processing. Um, Let me give you this scenario. There's another scenario which illustrates some of what I'm saying. Okay. Emmy goes to the United States in 2015. At that time, she was admitted as a tourist for 3 months. She stayed for 8 months and left on her own. Right. So she stayed 5 months, later than I guess that she was admitted for originally. 11 months ago, she was admitted as a tourist. Apparently, they didn't catch any prior infraction. So, again, for 3 months, she hasn't left and has been working without permission. Okay, I mean, it seems a little convoluted, but it's also very common. And Emiko just married a U.S. citizen. Can she become a lawful permanent resident? Well, we know that lawful marriage to a U.S. citizen makes you an immediate relative. And so she qualifies, but then how does she get um, the question, how does she get the green card? Does she go through consular processing or does she do adjustment of status? But let me focus on the inadmissibility question. Is she inadmissible? Okay. Um, I'll get to this in a second, but let me give you the overview and then I'll get to the statute. The prior entry without inspection, sometimes known as an EWI, entry without inspection, the prior EWI alone does not make her inadmissible as long as she was not deported formally, right? If she was deported formally, then that's an independent admissibility ground. But let's say that she submitted for 3 months, overstayed by 5 months, and left on her own. Um, then, but notice that the 5 months is not. Well, let me just say this: 5 months is about 150 days. That's the key thing to remember. Um, and the second and the second time she's been in the country without status for 8 months, right? 11 months ago, she was admitted as a tourist and then went out of status 8 months ago. So that leaves 8 months of unlawful presence. She's been working without authorization. Um, so the question is, what's the problem? I guess that's the question. So just remember these facts. Came in for 3 months, stayed for 8, left, came back 11 months ago, admitted for 3 months again, hasn't left. So she's been here for 8 months. So it's 5 months plus 8 months at a different occasion. She just married a U.S. citizen. She's a qualifies for a category, but is she inadmissible? Okay, so now I'm going to go to the next slide. Um, okay, so I'm showing you the statute. I don't expect you to absorb it now, but the reason I'm doing this is to kind of illustrate. This is more an illustration than a actual, it's sort of a meta teaching moment more than a real teaching moment. But all this stuff is regulated by statute, or actually not all of it, but a lot of it's regulated by statute. There's a statute on prior unlawful presence as an admissibility ground in 212. This is Immigration and Nationality Act 212, and it is also part of 8 United States Code. The numbering is different. INA 212 is the same as 8 United States Code 1182. So that number can be confusing. You might read a court case that uses one numbering system. Immigration lawyers tend to use this numbering system of 212, but you might find a court case evaluating its constitutionality or construing it that speaks of 8 USC 1182. Same statute. So notice what it says here is that 9B is the inadmissibility ground for so-called, statute uses the word aliens, aliens unlawfully present. And it says that the bottom line of the slide is inadmissible. So who's inadmissible? You're inadmissible if you're unlawfully present in the United States for a period of more than 180 days but less than 1 year. I've highlighted the key stuff. And then you're inadmissible if you try to come back in fewer than 3 years. This was often called the 3-year bar. If you've been in the United States unlawfully for 180 days, you have to stay away for 3 years. It's inadmissibility for 3 years. And then the next part says if you've been unlawfully present in the United States for 1 year or more, then you have to stay out of the country for 10 years. This is so-called 10-year bar. Okay, so one thing is that the case law is clear, and at least prior administrations have conceded that you do not aggregate these times, that you don't add these times up. So the first time was under 180 days. That doesn't really have an effect. The second time is between 180 days, but in 1 year, and it's not a 10-year bar. It's a 3-year bar. But here's the other piece of this that's important to remember. These bars only apply to you if you leave the country. These bars only apply to you if you leave the country. It's written that way. Kind of perverse drafting in different ways, but that's what the statute says. So notice this is actually the consequence of making adjustment of status difficult. It makes it difficult because it puts you in a zone of uncertainty as to the outcome and as to the duration of having to go, of course, plus the expense. It reduces your access to judicial review. But notice that someone who adjusts the country in the United States can avoid the 3 and 10-year bars because the bars only apply if you leave, and adjustment of status means you can get a green card without leaving the country. So I'm just illustrating how this is grounded in the um, um, I have a question here. Would the 10-year bar apply to a DACA recipient who's left the country or um, has been removed? It depends on the circumstances of when they leave the country, how they left the country. Um, if they left the country under something called advanced parole, it would be treated as if they had not left the country. And I'll talk more about that in a minute. By the way, I'm sure you all get a sense of, oh my God, this is incredibly complicated. Yes, it is. But it's also quite, it's something you can master. I don't have any, doubt or concerns about that. And just to take a more, you know, human aspect of this is that a lot of what you can do, or what immigration lawyers can do, is to be the person that explains this really crazy system to people in a way that really helps them make their lives better. On the one hand, it's very technical. On the other hand, it's something that really matters to people, and it's a role that you can play. And I've had students tell me that their clients named their firstborn children after them because it was so important what the lawyer was able to do and get someone asylum or a green card. And um, obviously it's not the reason that you do this work, but it's a sign of how you can really um, help people. And part of, I think, what it means to be a good immigration lawyer is to be so attuned to the practical aspects, so attuned to the emotional and human aspects, but also say, I'm going to help you with something that is very technical, um, and 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 help them navigate because you're really kind of a navigator. You're that kind of a guide. And obviously, being a guide includes a lot of things that are not law, but you have to know the law too. Um, by the way, this is what you argue. Sometimes the politics will make it harder than at other times. That's the prediction. But again, those are two things I think you learn in law school, although they're rarely phrased that way. But you just learn how to argue and you learn how to predict. Um, Okay, you also learn the law, but you also learn how to help people with it. Those are also obviously related, but they're worth focusing on in different parts of your being. Um, Suppose though you have to leave the country to get a green card. What can you do? Are you basically stuck out of the country for 3 years or 10 years? Not necessarily. There are waivers of unlawful presence. So I'm just doing this to illustrate how waivers operate within admissibility grounds. You qualify, you have the 3 and 10 year barrier apply to you, but you have to leave the country because adjustment is not available to you for some reason, either under well settled, old law or because the Trump administration doesn't want to adjust people. Um, the highlighted language talks about how if your son or daughter or spouse a U.S. citizen or of a lawful permanent resident and you show extreme hardship, you might be able to get a waiver. Um, and this is obviously less good than just qualifying, but sometimes people get waivers, and there's a whole art to making the case for making a waiver, for getting a waiver. Um, so this is an illustration of qualify in a category. You still have to avoid an inadmissibility finding. Um, if you aren't admissible, you might get a waiver. Sometimes waivers are available, sometimes they're not. If they're available, it's typically a discretionary decision. There are a lot of discretionary decisions in the immigration system. And one of the concerns that I have is that the tone being set from the White House is, so begrudging and hostile that, you know, I don't honestly trust the government to make the kinds of discretionary favorable decisions that it once did. In administrations, by the way, of both parties. So let's talk more about adjustment of status. Who can adjust status? Who has to leave the country? Notice what this says here. Adjustment of status. Um, this first part of the statute says you have to be inspected and admitted or paroled, and you have to be eligible for an immigrant visa, and the immigrant visa is immediately available. So let's take a situation where someone is in the country, they're married to a U.S. citizen, so that would make them eligible to receive an immigrant visa. Let's assume they have no other reason why they're not going to get a green card. There's no inadmissibility ground applies to them. So they're eligible to receive, and they are admissible. And the immediate immigrant visa is immediately available. You know that because immediate relatives don't need to stand in line. They need processing, but they don't actually have a line like the preference categories. But they also have to be inspected or admitted. Um, so bear that in mind. If someone came across the border without inspection, then they would not fit into this category. Um, now, so I'll come back to that in a minute. Well, actually, no, I should get into that now. So we got a question a few minutes ago about a DACA recipient who's left the country or been removed. Let's assume the first time around the DACA recipient came in by walking across the border or was carried across the border often as a young child, as an infant maybe. That person was not inspected or admitted or paroled, and so person would not be eligible to adjust. But um, uh, especially under the Obama and Biden administrations, you got permission to leave the country and come back, called advanced parole. Notice how when you do that and come back, you're actually paroled into the country. So it basically erases the shortcoming in your file that you were never inspected or admitted or paroled. So so that's how people who might seem not to be eligible for adjustment can actually adjust. Um, Now, I should move on to another aspect of adjustment. This is again the statute. Notice how what this says, what the yellow highlighted stuff says in plain English, is that another thing that can keep you from adjusting is if you work without papers. Um, but notice that unauthorized work does not disqualify you if you are an immediate relative. So in the case that I just provided, where someone is trying to adjust status who entered without inspection, let's say they've also been working unlawfully, which is often the case, um, that person can erase the defect of not having been admitted or paroled by getting advanced parole. And that person can also is exempt from the unauthorized work disqualification because it says other than an immediate relative. So immediate relatives are exempt from um, 245C. I mean, just to take a step back from all this, I mean, 245A sets out basic criteria. 245C disqualifies some people. But then 245C also contains exceptions to disqualifications. And if this seems unfamiliar, um, it will be all too familiar if you take an immigration law class because it's all about exceptions to exceptions to exceptions. And I'll say something a little bit later about why it's there. But I got a question in the Q&A. It says a reason why they uses the word son or daughter instead of child. Yes, there's a big difference. Um, a child is a son or daughter who is under 21 and unmarried. If you are an offspring and you are under 21 and unmarried, you're a child and you're in the best position. If you are over 21 or if you're under 21 and married, then you go into if one of the family preferences. So you may be subject to a line, um, and you may be subject to per country limits. So that's an important thing about the difference between a child and a son or daughter, because that's a very natural thing. I mean, child is a term of art here. Um, so that's adjustment of status. Let's move on to talk about sort of so-called removal proceedings, which is deportation hearings and detention. One thing to where the administration's been doing a lot of damage here is that it's been true since for a long time, but at least as far back as 1996, that some non-citizens don't get full removal hearings. There's expedited removal, which is basically you get just a hearing, not even a hearing, but decisions made by a border official, not an immigration judge. There's reinstatement of removal, which says that they reactivate old deportation or removal orders. In many of these cases, the person didn't know about the original case. They never got notice and they were ordered deported without being there. That's called removal in absentia, and it's reactivated. Lately, we've been seeing fast track dockets of various kinds. I mean, basically, people not given much of a chance to, even state what their case is. They just order deported. I mean, the administration is really intent on upping the deportation numbers, and one of the ways they up the deportation numbers is they basically figure out some way to not give you a hearing. Um, um, and Another thing that's important during this whole deportation or removal proceedings process is detention. Many people, one issue is, are you subject to mandatory detention? Congress, um, basically said you have to be held in prison basically while your case is pending. Sometimes that it's mandatory, and in many cases, that detention can take a really long time, measured in years. My co-director Ahilan has really been arguing this for many years, including several times in the U.S. Supreme Court about whether this is even constitutional. A lot of good arguments why it's not. Um, there's also detention about for people who are they're ordered removed, but they can't be sent to another country for various reasons. Sometimes they're people who are stateless. Sometimes their country won't take them back for various reasons. And I want to mention self-deportation because I think a lot of what the administration is trying to do is to get people to leave. This is an example of the difference between law and practice. The law says one thing, but the administration, I think, is trying to scare people to leave, so they don't insist on their rights, or that there's only so much of this you can take. So that's what's going on. Um, Immigration proceedings in immigration court. If you do get to immigration court, often one issue is detention. Or will you be detained while the proceedings are going on? Um, and the issue beyond detention is if you've not been admitted, are you admissible? If you have been admitted, are you deportable? I'll say more about deportation in a minute, but and even if you're admissible or you're deportable, is there any other relief you can get? I'll talk more about that. But asylum would be a form of relief. There are other aspects of getting discretionary permission to stay. And obviously, due process is a huge issue here. There's no right to appointed counsel in general, but in prior criminal proceedings, the Padilla case from now 16 years ago says that effective assistance of counsel requires advice on immigration consequences of criminal convictions under many circumstances. Although, practically speaking, a lot of this has been chipped away at, but it's still important, and it's the reason why a lot of public defender offices have immigration counsel now. Sometimes the route to take is not to save someone or try to make a case in immigration court, but rather to get post-conviction relief in the criminal justice system. Um, okay. What else we got here? Just a word on deportability. People who've been admitted, they may become deportable. They could be non-immigrants who overstay. They could be non-immigrants who work when they're not supposed to, or they could be permanent residents who become deportable. And one big example of this is criminal convictions. And then these terms that keep coming up, I mean, crimes involving moral turpitude, aggravated felonies, crimes of violence, these terms always come up, and there's a lot of case law defining each of these. It's also important to determine what is a conviction. Sometimes deferred sentencing. In fact, most times deferred sentencing is a conviction. Deferred adjudication sometimes is not. It depends on state law, and it really matters how long you've been sentenced for. That's one of the reasons why California, reduced the sentence to 364 days because that would make it under 1 year, and that would have consequences for deportability under federal law. And again, post-conviction relief might be the only way you can go. There are waivers of deportability as well. And another thing about deportability, practically, is what's the degree of state and local cooperation with DHS and ICE. Okay. Um, so I'm going to go through this example a little bit more quickly because the examples I'm giving are less to convey the details of the law, but to kind of illustrate how you research this kind of thing. Francis was admitted to the United States as a permanent resident in 2013. He committed theft in 2018, was convicted later the same year, sentenced to 6 months or 2 years in prison with all but 6 months of the sentence suspended. Is he deportable? A case that you might get, for example, if you're working at public defender and you're trying to evaluate a situation or trying to evaluate, actually, a lot of this comes up when you evaluate a plea agreement. A lot of this happens ahead of time. It should. The whole point of idea is that you think ahead, not that you're trying to, solve a problem after the criminal defense lawyer has and the prosecutor have created it. Um, so um, this is, I'm not going to go, I shouldn't go through this in great detail, but this is just to show you that there are different concepts of things that can make you deportable, based on a conviction. Could be crime of moral turpitude committed within 5 years. Um, it could be multiple criminal convictions. It could be a so-called aggravated felony. Notice that aggravated felony makes you deportable no matter when it happens. Crime involving moral turpitude, um, a crime involving moral turpitude, it might mean that you're not deportable if it happened after 5 years in this country. So that's just um, that's just an illustration of how the statute goes. But notice there are in the INA in section 101, there are definitions. So here's 101A43 defining aggravated felony. Um, theft offense, burglary offense, term of imprisonment at least 1 year. They forgot to leave a verb. Congress forgot to put a verb in the sentence. That's why it says sick, but it probably means imprisonment, term of imprisonment, for which the term of imprisonment is at least 1 year. I guess that's what that means. This is the definition of conviction. Um, and um, and and notice how the term of conviction is regardless of any suspension of the sentence. That's what 101 A 48B says. Okay, I went through that quickly because it's just an illustration of basically how you do this stuff. Um, this often comes up in public defender offices or in a lot of offices, I guess. This goes back to a question from earlier about relief. There are different defenses to removal. You could be removable from the United States, but you could get cancellation. That's a narrowly available discretionary relief that can allow you to keep your green card or can even give you a green card if you're undocumented, but it's very hard to get. Defenses to removal include humanitarian protection, asylum, withholding of removal, which is a similar but less favorable form of protection against persecution. You could, Convention Against Torture, temporary protected status. There's also a lot of prosecutorial discretion. DACA is an attempt to basically create a program to treat a group of people by giving them, as a matter of discretion, protection from deportation. There's also other people can get deferred action. One of the famous old deferred action cases involved someone you may have heard of, named John Lennon, who was in a band once called the Beatles. Administrative closure is putting you on the back burner, but the administration has been on a crusade against getting rid of that too. Um, Even though that adds to the backlog that they're complaining about. So, um, okay, so federal executive branch. This is just you may see these terms. This is not so much law, but just sort of landscape. President. There's four cabinet departments that I think are worth thinking about. Homeland Security consists of a number of units, but Immigration and Citizenship Services is deciding petitions and applications. Could be naturalization. It could be, family or employment preferences. It could be deciding sponsorship, fiscal support. It could be deciding immediate relatives. Immigration, ICE is the Interior Enforcement Agency, as you probably know. Customs and Border Protection consists of people like at LAX, but it also consists of Border Patrol. Department of Justice is separate, although obviously reporting to the president and highly politicized. Executive Office for Immigration Review, or otherwise known as EOR, is where the immigration courts are. These are employees of the Department of Justice, and this administration has really tried to get rid of all the people that they thought were, too immigrant friendly. In fact, their advertisements for replacing them, they advertise for deportation judges. So that tells you where they're coming from. The Attorney General is above, EOR. It's really the ultimate, basically the cabinet officer in charge of the Department of Justice. The State Department does immigrant, non-immigrant visas outside the country. So if you're dealing with a consulate, you're dealing with State Department people. Certifying that employment-based um, preference immigrants qualify in these categories. Often that falls to the Department of Labor, and labor certifications is showing that you're not taking a job away from American worker. Wage determinations are meant to determine that you're not undercutting U.S. wages. Okay. Um, let's see here. Okay, federal courts. Just a few things to keep in mind. Administrative law principles. One of the things that's become really important, especially since 2016, is a lot of immigration lawyers, especially if they're in litigation, but more generally, if they're thinking about whether, a lot of times you ask, can they do this? A lot of times the reason they cannot is not the Constitution. It's because it violates administrative law principles. Um, a few things here is that there was a doctrine called Chevron deference, which means that agency interpretations of statutes get deference from the courts. In theory, that's gone now. But often cases were decided during the era of Chevron deference, and so you have to interpret like how much is left of that precedent and how much has been made obsolete. Um, the, the Supreme Court seems to adopt something called the major questions doctrine that says that major questions should not be left to agencies. Another one I should add here, it's kind of a bad omission actually, is the Administrative Procedure Act. Makes it so the government has to make decisions certain ways, and many of the cases involving many of the challenges to what the administration has been doing, especially this administration, though it's been part of litigation for many years, is violation of the Administrative Procedure Act, which um, regulates how the administration has to make decisions. They have to publish things in the Federal Register, go through a process of notice and comment. And so a lot of the attacks, like the TPS attack, on the attack on the Trump administration's, attempt to basically take away TPS. One of the major problems that's defective is that it fails to comply with the Administrative Procedure Act. So there's a lot of ad law in immigration law, especially now. Federal courts get involved too, outside administrative agencies. District courts often are the place you go to seek release from detention. It's often where executive branch regulations and policies are challenged. One of the things the Supreme Court did in a case called Trump versus CASA is to limit the availability of nationwide injunctions. And so, in theory, you're not supposed to, it's less possible than before to go to district court and get a nationwide ruling striking down a federal regulation. Um, you can still do that, but it depends on the plaintiffs you have. And and oftentimes the federal courts are where you go to challenge state and local laws and policies. That can be done on both sides. California has had its sanctuary legislation challenged with mixed results by the federal government in federal court in California. But the challenges to state sort of restrictionist or pro-enforcement laws, those are also conducted in district courts. And courts of appeals are one way. That's where you appeal orders from. If let's say you're ordered removed, you can appeal that to the Board of Immigration Appeals, and after that, you can appeal it to the Court of Appeals. You bypass the district court, and of course, the Court of Appeals takes decisions from all kinds of other cases, including, the citizenship cases or TPS and then of course the Supreme Court is there, and part of its decision making is in the traditional way, but a lot of the concerns that a lot of immigrants' rights advocates have had is the use of the Supreme Court to issue decisions without briefing, um, and the so-called shadow docket. So and those decisions have often been to there's a one big example is a district court opinion in Los Angeles that struck down ICE enforcement practices that relied on racial and ethnic language accent profiling, and the Supreme Court stepped in and said, well, we're going to put that decision on hold until this, it could be for years. But they did that without a full set of arguments. And this is not just immigration law. The Supreme Court's been using the so-called shadow docket in this way. I got a question about whether EO courts are subject to the EPA. It really depends on what they're deciding, right? I mean, it depends on, there's a whole lot of law on what things the EPA applies to. I mean, basically, if it were like a regulation or something, um, chances are it is subject to the APA, but there are a lot of decisions that don't rise to that level, and they might not be. I know that's kind of a vague answer, but I mean it's kind of the it depends answer. But it really depends on whether it rises to the level of formality that the APA constrains. Okay, another big topic, but I just want to say something about this. I've been focusing on the federal law. I've mentioned state and local governments a bunch of times, but here's what happens. And by the way, I mean, in each of these slides, the careers of many people would fit into one of these slides, right? So it's state and local government could be its own course practically in immigration law. So officially, federal government has exclusive authority over immigration law. Um, but there's a couple of but that means sometimes that authority is delegated to state and local governments. That's an example of that are so-called 287G agreements that basically deputize state and local law enforcement to enforce immigration law. That's one, so you could delegate this authority. You can also, federal government often says that federal law preempts sanctuary legislation. And so the argument is that California tries to do something, the federal government comes in and says, well, California can't do that. It's preempted by federal regulation. So there's a lot of arguing back and forth over that. One thing I'll say about that is that a lot of things you might look preempted, but they're really not. And the reason is that states have a long history of doing things, enacting laws that affect the lives of immigrants. And that's not deemed to be immigration law enough to trigger preemption. So so it's really a huge gray area about where's the zone between what the federal government can do and what the state government can do. Um, and then this second main bullet point gets to preemption of other state and local laws for non-citizens. I think it's the Supreme Court decided about 13 years ago that state laws that kind of go after the same people that federal law goes after, that's not enough to be preempted because sometimes federal law is to allow people to stay. And if the state government goes after people the federal government will allow to stay, that should be preempted. It's a conflict. Um, that raises the question, what is immigration law, right? I mean, in theory, the state is only going after people that's not supposed to be here under federal law. But in practice, you know, that's not really, in practice, the federal government won't go after people. Is it okay to let the states go after people? And then sanctuary laws are, I mentioned, but I just think it's important to remember that there are a couple kinds of sanctuary laws. One type of sanctuary law that's often what people think of as laws that provide no help for federal enforcement. But I think equally important are laws that integrate people regardless of their status. In-state tuition, driver's licenses, they're a different kind of sanctuary um, 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 provisions. Yeah, one of the questions I got in the Q&A is in Texas, preemption debates can occur in debates about states to try to enforce immigration laws. Absolutely. One of the big immigration cases involving preemption was the United States versus Arizona. And that was a case saying that, the Obama administration brought and said, well, Arizona has no business trying to enforce immigration law. That's preempted. And so, there's in all these cases, lawyers try to draft around the prior statutes. I mean, that's what lawyers do. And so it's not cut and dried what will happen in any of these cases. But the issue with Texas, or in many states, is the state law going too far in terms of enforcement by going further than the federal law the federal government wants to do. The political posture for this is really complicated now because the federal government is colluding with friendly state governments, and so they've, in some cases, gotten the state to say that in-state tuition for undocumented people violates federal law. I'm not. I think in many cases it maybe in most cases or all cases it does not violate federal law, but it's almost like two sides collude to put that result in, and so that's another set of issues. So I think this is actually my last slide, which is good because I only have 3 minutes officially. I can't believe I actually got through all this. Um, Sorry, I've been talking so fast. If you want, you could get the recording and slow down the speed. Listen to it again. Um, so this is just some sources. Again, we can make these slides available to you. So you have all this. This is a case book that I'm the co-author of. Forthcoming July. What that means is that by next Tuesday we have to sign up on the final version of it. It'll be going to the printer really soon. Richard Boswell's book is a really solid introduction that is a digestible summary of what's going on. Our casebook, by the way, is a is a it's a casebook, but it also tries to it ranges broadly, and I think it really has been challenging, but I think doable to um, capture for purposes of conveying what you really need to know the things that are both constant in the law, but also the trends that we need to keep our eye on. Um, the Kevin Johnson book by Kevin Johnson and others is Understanding Immigration Law. It's another, sort of a short, well, it's not short actually, but it's not a case book. It's really a book that's a summary of it, of the law. Ira Kurzban's book is a book that I think it's like thousands of pages, a very thin. Um, it's basically the book that it tells you all the sources about anything you could possibly think of. You have to know the law to use it, but if you know it and you want to find a case that applies judicial review to the denial of a waiver of a particular section, it'll be there. Um, the Mailman, et cetera, immigration law treatise, law and procedure treatise is part of Westlaw and Lexis. Um, in on paper it's like 25 or 30 volumes. It's really it's got everything. It's even more detailed than Kurzban. Interpreter Releases is a weekly that's available on Westlaw. You can find out what the latest is on anything, and obviously you can use search terms to find everything. Vendors Immigration Law is a little bit broader frame, but it's also part of LexisNexis, and it has more interpretive articles and also some latest developments. The Migration Policy Institute is a really good source of just reports on what's been going on, like what's the latest on whatever it may be. And some of it can be international, some of it could be like, here's what's going on with asylum now, here's what's going on in Congress. I have 3 books I've written now. The last one, the most recent one, is called Borders and Belonging, which is really, kind of sort of a broad take on immigration policy. It's actually available in audiobook now. Wherever you get your audiobooks. It's not me reading it even. They actually got a real voice actor to do it. And if you want a 16-minute summary of everything I just said, so it reduces the 16 minutes to it reduces the 90 minutes to 16. You should, if you Google "Try Guys Try Immigrating to America," you'll get some of you may know who the Try Guys are, but it's sort of I guess it's a comedy group of people that would be a combination of John Oliver and Monty Python or something. I'm the straight man in this video that is kind of this crazy, serious. It's attempt for a comedy troupe to address a very serious topic. And anyway, it must be okay because it has like 7.3 million views. But it's my entire class and much of my life compressed into 16 minutes of zany humor. Um, so. Um, Guess what? It's exactly 1:30 in California. So that's all I got. Thanks for being here.
Thank you so much, Hiroshi. For folks who didn't see the chat, I'll be sending out written materials and a link to the YouTube channel where you can find this recording. And we really appreciate your time. Thank you again.
Thank you. And yeah, thanks for all your work.